file 53020, 53021, and 53022.
Good morning. We're back on record in this file. May I have the names of our participants, please?
Bert Castleberry on behalf of the petitioner Tanya Zubers.
Tanya Zubers.
Alexis Stang on behalf of Andrew Alexander and Tanner Scowen.
Thank you. We confirmed 2 days ago that Mr. Skelton did not want to participate. He also did not log in this morning, so we're assuming that his continued position is that he does not want to participate. I have prepared a written opinion that describes the impressions of the court and the findings, so I'm just going to read that aloud for you this time. This order settles the matter raised by Tanya Zubers' petition for declaration of death December 12th, 2024. I'll fix that. Pursuant to MCL 700.1209 subsection 2. After review of the evidence, testimony, and current law, the petition is granted in part and denied in part. Pursuant to MCL 700.1209 subsection 2, a party may move to declare a person deceased under the following circumstances. Sorry. An individual whose death is not otherwise established under this section, or section 1207, who is absent for a continuous period of 5 years during which he or she has not been heard from, and whose absence is not satisfactorily explained after diligent search or inquiry, is presumed to be dead. The individual's death is presumed to have occurred at the end of the period unless there is sufficient evidence to determine that the death occurred early. The petitioner asks this court to find sufficient evidence to determine that this child, along with his 2 brothers, passed away on the night of their disappearance, rather than after the period of presumption. Such a finding requires a showing by clear and convincing evidence. Although this is not a criminal trial, it does not pretend to be one, such a trial does require the fact finder to consider the evidence and testimony under the rules of evidence, weighing credibility of witnesses and reliability of evidence in this respect. At the one-day trial, 5 witnesses were called to support the petition with the aim to provide the court with clear and convincing evidence that John Skelton was responsible for not only the disappearance of his children, but the murder. The 3 law enforcement officers testified, including Chief Larry Weeks, formerly of Morenci Police Department, FBI agent Corey Barris, and Jeremy Brewer, Michigan State Police Detective assigned to the case in 2013. All offered their opinions that John Skelton was responsible for the murder of these 3 children. Tanya Zubers, the mother of the children, also agreed, even though she shared during her testimony that she had held out hope for many years that the boys were not dead. Cold case expert Kelly Hodges was the only other witness, called to confirm that she had run approximately 20 database searches on the state and federal level, including facial recognition, with past and all sets of age progression photos. The last search concluding in August of 2024. She found no proof of life after November 25th, 2010. The testimony provided by law enforcement officers included a very high-level presentation of events, which relied heavily on layers of hearsay from statements, sometimes second, third, or even fourth-hand accounts, reports, photos, and other non-specified records. This raises a very serious barrier for the petitioner to reach the burden of clear and convincing evidence necessary for the court to find the children were murdered by John Skelton. Chief Larry Weeks' testimony reflected direct observations of the home and direct interactions with John Skelton at times, both before and after the disappearance. His firsthand observations included events on September 13th, 2010, when John Skelton threatened to take the 3 boys to Florida. His report on the event was entered into evidence and reflected that he and a Michigan State trooper, quote, stood by until it appeared that things were civil enough for us to leave, end quote. He also testified to arriving on scene to the Skelton residence and observing the home in, quote, disarray, quote, on November 26, 2010, likely sometime in the afternoon. He shared that a fellow officer had removed a noose, quote, noose, and put it on a door handle, and that some other family members had already gone through the home looking for the children. His only further description of the home included broken glass and cabinets, cords to appliances cut, a Bible open to a highlighted verse, and a suicide note found in a notebook. Aside from his own attempts to access a computer, the remainder of his testimony recounted what he remembered of statements made to him by fellow officers, family members, and others. It was unclear what pieces of his testimony were from his own observations or from reports or statements that he may have recalled information. These weaknesses in the testimony were never explained by any exception to the hearsay rule, nor supported with the testimony of witnesses he referenced, photos, or any other records. This has the unfortunate result of undermining the reliability of his testimony as it relates to the request that the court determine a murder occurred. He shared the extensive efforts to search for the boys, however, referencing search tools such as maps of the area used daily to brief fellow searchers, and verified that no one had seen the boys after November 25th, 2010, himself included. The next witness was FBI agent Corey Barris. He was assigned to the case and arrived at the Skelton home in the afternoon of November 26, 2010, staying overnight. He described the home as, quote, destroyed, quote, with a bed sliced up and a noose hanging from a banister. The remainder of his testimony consisted of his recounting what he learned from analysis of John Skelton's laptop and of the text messages and conversations between others and John Skelton in the days following his assignment. It is again unclear how or when he came into such information, as during questioning from the lawyer, guardian ad litem for the child, he confirmed he had never had any direct contact with John Skelton. This is another unfortunate concession, given that his testimony up to that point covered many of the pieces of evidence the petitioner would purport to use in supporting the request to find that John Skelton murdered his children. Michigan State Police Detective Jeremy Brewer testified most extensively as to the investigation, including presenting a 4-piece timeline citing when various events occurred, including pivotal pieces of evidence used in his investigation. Detective Brewer took over the case from Chief Larry Weeks when Chief Weeks left Morenci Police Department in 2013. There is no question Detective Brewer spent years piecing together his timeline and vigorously pursuing this murder investigation into John Skelton. He shared with some gravitas that he had gone through a mountain of documents to prepare his timeline. Unfortunately, none of those supporting documents were provided to the court to substantiate, verify, or authenticate the events on the timeline. His testimony did include, however, his recollection of several different interactions with John Skelton, including a confrontation with him involving Moses Gingrich, whom John Skelton had directed him to find in order to try to find out where the boys could be found. He verified that despite extensive searching, including dredging a small lake at a campground, not one of the boys has been seen or heard from since November 25th, 2010. This is a case of terrible and long-standing impact on the community of Leonard. No condolences will ever be enough for such losses suffered. These proceedings offer an opportunity to recognize the disappearance and death of these 3 brothers, but leaves many more questions unanswered. Such a voluminous amount of work by law enforcement will never be fully recognized or credited right, especially when such a loss still remains unresolved. Thank you. Alexander William Skelton, Andrew Ryan Skelton, and Tanner Lucas Skelton have been missing since November 26, 2010. Given their undisputed disappearance for over 14 years, the statutory presumption of death applies. Presentation of evidence, however, does not present clear and convincing evidence that John Skelton murdered these children. The information provided at this trial provides ample opportunity for speculation and theories, but to make such a finding, the court would only be joining those voices offering such speculation and theory, given the lack of information. The impact of this ruling is not lost on this court, for it is also a part of this community. but the court must follow the law. And to ignore it in this case risks the very structures upon which our system of justice is built. Thus, it is with the gravest of condolences that it is ordered Alexander William Skelton, Andrew Ryan Skelton, and Tanner Lucas Skelton are presumed to be deceased as of November 26, 2015, in accordance with MCL 700.1208 subsection 2. Questions?
Oh, yeah.
No, thank you.
Thank you, everyone, for your time, efforts in this case.